research, doing research in mediation. Alternative dispute resolution happens to be my primary research and teaching area. So, I read a lot of literature on mediation. Mediation is something presented as a panacea for all the ills plaguing this legal system of ours. But can we really think about why this is being offered to the masses? What's the reason behind that? And the often quoted reason, which is always presented to the masses, is that courts are jam-packed with unending number of litigations. So meaning thereby, when the courts will become free from all the unending number of litigations, some 430 years down, 430 years from now, then mediation will be taken off. So, therefore, it compels us to think whether mediation is indeed a sort of justice which we like to have. Is it a primary form of justice, primary form of dispute resolution, or is it some kind of secondary dispute resolution or a secondary form of justice? Well, I'm not here to deny the beneficial claims of mediation, because I believe strongly that, of course, parties arriving at the dispute settlement through consensual process is something which is actually more desirable, and the law also must promote it. But the kind of mediation actually happening in India is something which I don't find, the parallels of those I don't find in the literature, and also nor in the practice of mediation in other jurisdictions. Like, I also spent some time in Europe, in Germany, and also in another country over there, Hungary. And so when I started doing research on mediation, I was quite startled and surprised to know that who crafted the mediation rules which you have. It's the San Francisco-based institution which crafted this mediation rules, which now the Delhi High Court administers in relation to mediation activities. So, the fact of the matter remains that if you like to have a mediation which is indeed suited to your culture and interests, you need not to borrow such ideas, because already mediation existed in India since time immemorial. Now, why I am raising concerns about mediation is the fact that right now we don't have any regulation. The one which is occupying, so in terms of regulating mediation, is the secondary form of legislation, that is the judicial legislation. In the Salem Advocate Bars Association, followed by AFCON's 2010, the Supreme Court guidelines on mediation now holding ground. You don't have any legislation whatsoever. Now, I need to raise certain question in this connection. If I may ask you this question, who can be mediator? What will be your answer? Is there any answer to that in your legislation? What is the credentializing process of mediator? Now, the most important factor, concern, whether lawyers alone can be considered to be mediators, the retiring judges, are they the ones who should be donning this mediation? Now, the fact of the matter remains that mediation is absolutely miles apart from adversarial system. It's absolutely different from adversarial system. Because in this system, because let me just give you some characteristics of this mediation. In mediation, there is a third party who is the neutral mediator. He actually facilitates the parties to reach to the settlement agreement. Now, it is expected that he would be able to do that in a neutral, impartial manner. But the most important factor is that the parties must volunteer themselves for mediation. A decision cannot be imposed on the parties. Now, these are some very essential qualities for non-adversarial practitioners. Now, voluntariness is one of the fundamental elements, and apart from that, another one is the self-determination. Self-determination. Now, when I was doing research, I was absolutely surprised that out of the 142 samples I gathered, in that only 22% of the respondents who were the parties actually said that they knew the meaning of self-determination. Very few of them actually said that they actually knew the meaning of confidentiality, which is the hallmark, the most essential attribute of mediation. We need to think about how to protect confidentiality also in the mediation. There are so many different dimensions of mediation. Now, we don't have any legislation. You have private, this Samadhan of the Samadhan High Court, and also their Ministry of Corporate Affairs. They are also running 40 hours mediation training program. Now, within that 40 hours training program, can one be expected to be a skillful mediator? Now, that's something which we need to debate upon. Who can be mediator? The lawyers are donning the mediation chambers. Are they really skillful? Do they have the non-adversarial mindset? They are just coming, they are doing it on part-time basis. We don't have any mediation cadre. Now, in United States, from where this, in 1996, Justice Amity called this San Francisco-based institution, I'm just forgetting the name of that institution, and then they came here, they conducted trainings, and they actually, supplied their own version of the mediation rules. We have just borrowed that mediation rules. We don't have mediation rules of others. So, therefore, what I would like to point out, because in the limited time, training is an important factor. We need to train people who are actually willing to be a professional mediator. The law must bring clarity to this point. Training. Now, you can have basic training in mediation, maybe for 40 hours, but for the advanced training, in order to make sure that we have specialized mediators, say for example, family mediator. Now you're facing all these problems of Section 498A related mediation. Now that's something which is actually alarming as well. Who is the person mediating such disputes? That being non-compoundable. So training is important. Another thing is the mediator's credentializing process. We also need, in most of the countries I observed, USA has Uniform Mediation Act, European Union came up with its own directive called European Union Directive. Most of the countries have enacted laws. They have actually provided clear-cut guidelines as to the mediator's credentializing process, and also professional ethical rules for the mediators to follow. India is all set. We don't know, most of you don't know, India is all set to experiment with this mediation stuff. In the next 10 years down the line, we are going to see huge mediation boom around the country. In some of the jurisdictions, like in USA, in some of the states in USA, they are now facing another type of litigation. Another type of litigation because they didn't have very proper, clear laws, legislation. Some of the states in USA. Now, those are called mediation litigations. Already, we have unending number of litigations, more than 3 crore cases are pending. So would we afford to have this barrage of mediation-related litigations hitting our already jam-packed courts? So, therefore, we need to devise, we need to debate, we need to discuss all the stakeholders, including the ones from academia who are always overlooked, ignored, while this process of law framing is done. So, we need to involve ourselves in order to define as to who can be mediator, what should be the process of licensing, credentializing, to my mind, 40 hours training, that's only basic training, is something cannot be sufficient. We also need to impart, advanced training. Some of the crucial questions in the whole mediation discourse is power imbalance. Mediation is often criticized for something which does not afford procedural fairness. The party which is, it is always argued that in mediation, the one who is better off, who is articulate,